So my name's Nick. I'm the Senior Housing Advisor at the University of London Housing Services. Today I'm going to talk to you about HMO licensing and rent repayment orders. So I'll explain what that all means in a minute, but it's just info for student renters about those topics. So before we start off, I'm just going to give a bit of context about the University of London Housing Services and what we do. So we provide a service to students that helps you find accommodation. So we've got a property platform on our website that has sort of properties from landlords, letting agents, private hall providers that you can use to find accommodation. Everyone on there accepts students. You can search by proximity to your university, so you may find that useful. We can also help you find flatmates. So we've run a couple of flatmate finders this week, but we also have a flatmate finding Facebook group that you can use to connect with other students. We offer a contract checking service. So before you start a tenancy, you can get your contract checked with us. And we also offer housing advice. So on topics like the one today, HMO licensing, but also on other things like disrepair or deposits if you have trouble with your landlord. So just bear that in mind, get in touch with us if you find that you have issues that you need some help with. So it is Housing Week 2021. We're kind of at the end of it now. This is our last Housing Week event. So you may have missed out on some of the things on this list here, but all the webinars that we've done this week are available to watch in our housing fair event, which was yesterday. The live event was yesterday, but the event space actually remains open for a full 30 days. So you've got sort of 29 more days now to go log into the housing fair, have a look at our webinars, watch through the other topics. So do that if you did miss some earlier in the week, because they're worth watching. Okay, so today what are we going to cover? So we're going to define what HMO is. You may have sort of listened to me talking about the word HMO and be wondering what the hell I'm talking about. So we'll find that out shortly. We'll talk about why licensing HMOs matters. We'll talk about whether your landlord needs a license for the property that you're renting, how to find out if your landlord has one, and what happens if they don't have one. And as part of that last section, we'll talk more about rent repayment orders, which are probably the most relevant thing about what could happen if a landlord doesn't have their property licensed. Okay, so what is a HMO? So HMO is a house in multiple occupation. Obviously, that's a bit wordy, so I'm going to keep saying HMO for the rest of the presentation. But a HMO is where 3 or more unrelated people live together in a property. So it's basically just a fancy word for a house share. It's not living in a family group. So if you live in a sort of single household family group with someone who you're related to or a partner, then that would not be considered a HMO. It's only if there's 3 or more unrelated people living together, sharing facilities, so things like kitchens, bathrooms, living rooms, etc. In that situation, every individual person is considered to be one household. So it's sort of like a house with lots of people living a bit more separately in it. It's a bit more complicated if there's a live-in landlord. So if there's a live-in landlord, it's less about the numbers of people in the property and more about the numbers of sort of renters. So say, for example, if you're a lodger in a family home and the landlord has their partner, their mother, and sort of 3 children there. If it's just you as a lodger, then that doesn't make it a HMO, even though the numbers in the house are greater than 3. It's only if the landlord has sort of more than two lodgers that then that becomes an issue. For the rest of this presentation, I'm not really going to be talking about scenarios where there's a live-in landlord involved. So just assume that I'm talking about a sort of live-out landlord where everyone in the property is a tenant. HMO licensing, so that's where the local authority basically approves the house as safe and suitable for the number of tenants that are being rented to. This is basically to prevent the property being in a poor state. We'll talk a bit more about the reasons for it in a second. There's a difference between a licensable HMO versus an unlicensable HMO. So not every HMO not every house with 3 or more unrelated people living together in it is going to need a license. It depends on a number of factors, which I'm going to talk about now. So as I said, so it depends on sort of the exact situation in that house. So only some will need the license. And just to be really clear, because students do sometimes worry about this, the HMO license is not your responsibility, it's the landlord. So there's no really conceivable way that you can get in trouble for lack of HMO license unless it's you who's adding lots of extra people to the tenancy without the landlord's consent. So say if you rented out a 1-bedroom flat and then brought, 4 housemates to live there with you, then yes, that would potentially be a problem. But if you're renting a property where the landlord knows who's all living there and is given that kind of permission, then it's the landlord's responsibility. There's difference between legislation. So there's England-wide rules that I'd refer to as statutory rules versus the rules of local councils. And this is where it can get confusing, especially in London. So let's first talk about what the rules are for the whole of the country, okay, the national legislation about HMOs. So that says that any property with 5 or more unrelated sharers in it, except purpose-built flats, requires a license from the local authority. So when I say purpose-built flats, this is kind of like a new bit of legislation that's been brought in 2018 by the government. So previously this wasn't part of it, but if a flat was sort of built with the idea of that number of tenants in mind, so say with 5 bedrooms, then generally it will be considered to not need a HMO license according to the UK-wide rules. However, if you live in a house or if you live in a flat that's sort of maybe part of a converted house, so it used to be a big house and now it's 3 flats, say, then if there's 5 or more people living in that house or converted flat, then it will definitely need a HMO license. But local laws can set stricter criteria. So the local council for that area can set criteria that says that more properties need licenses than just those statutory rules would normally suggest. So they can't make the rules more relaxed. They can't say, we're not going to have any HMO licensing in our borough. The statutory rules always apply, but the local laws can make it stricter. So when we talk about those local laws, I'll use one of 2 phrases. So one is additional licensing, which is local rules that apply to the whole borough. So because we're in London, we're talking about London areas. So a borough is sort of like the area that local council controls. And there's 32 of them, I believe, in London. The additional licensing will cover that whole borough. There's also selective licensing. So those are rules that only apply to part of the borough. So say, for example, if there's a particular road that's got a lot of rented property on it and a lot of it is kind of people kind of crammed together, maybe in flats above shops or things like that, and they want extra rules to make sure that there's not overcrowding, then they might have selective licensing just for that one sort of road or the area surrounding that road. This can also mean that houses that don't even meet that definition on the last page of a HMO, so the 3 or more unrelated people living together, sometimes they can become included in the selective licensing law. So maybe even a 1-bed or 2-bed flat would need a license under these rules. So I hope that makes sense to everyone. It's a bit to get your head around, but we'll keep talking about it, so don't worry. Just quickly, I just wanted to kind of mention why you should care. So a lot of students aren't really that bothered about whether or not their landlord is following all the rules. If they found a property they like the sound of and the rent's cheap, that's all they're really interested in. But I just want to talk a bit about why HMO licensing is important and why you should care. So being in a HMO just increases the risk of hazards. Generally, things like fire especially are probably the biggest concern when it comes to a HMO, fire and kind of adequate fire escapes. So the reason why that is if you can imagine, like in a family, you might just be cooking 1 meal for everyone every night. But in a HMO where everyone's living separate lives, maybe you don't even know the people you're living with, you're all cooking different dinners, there's lots of different potential sort of fire hazards going on at once. People aren't as accountable to each other, so they don't necessarily know what their housemates are doing all the time, whether they're home or not. In the case of a fire, you may not know who's even in and whether anyone needs rescuing, for example. So it's really important that there's kind of easy fire escapes for everyone. And HMO licensing makes sure that there's adequate kind of fire doors in a property, for example. It makes sure there's adequate fire alarms. It also prevents things like overcrowding. So councils will set rules on the minimum room size per adult, for example, and the minimum size of a kitchen, or the minimum amount of kitchens if it's a really big HMO, lots of people. And And if the landlord's not providing that and the property is unlicensed, then it could mean that there's real problems of overcrowding. And you may hear about kind of slum landlords, so people who are cramming, say, I don't know, 15 people into what would normally be a 3-bedroom house. They can maybe doing things like subdividing the rooms, or just cramming lots of people into bunk beds, for example. And HMO licensing stops this kind of practice. So that's exactly what it's designed for. Often landlords who don't have HMO licenses as well are breaking other laws. So you can pretty much reliably often predict that people who will not have a HMO license also won't have protected your deposit, which, if you don't know about, I highly suggest you watch our webinar on deposits that's available to watch at our housing fair, because that explains deposit protection. But it may be that they're doing other illegal things. Maybe they've not wired the electricity in properly, they're not doing their gas safety checks. HMO licensing basically ensures that a landlord is doing all that, and if they don't, then it will mean they won't get the license and they won't be allowed to rent the property. So, as I said, London can be quite complicated for the rules, and this map is just to show you a bit about what I mean there. So if you have a look at the boroughs there that have the kind of less coloured in, those are the ones that just have what we refer to as the statutory law. So the UK-wide law that says that 5 or more sharers needs a license. The ones that are more coloured in, so these kind of slightly transparent ones, they have maybe additional licensing for some properties. And then you have these ones here that are filled in completely. So I think this is Newham. So Newham says that all properties have to have a license that are rented out. So that's why it's kind of filled in. So as you can imagine, this can create a kind of situation where you can be on the border of one place. So say, I think this is Camden, Westminster here. You could live there, and on one side of the street, your three or more sharers house share could need a license, and then on the other side of the street, that one doesn't. So this is just the point I'm trying to make, that the geographical thing can make a big difference. Sorry, I think, oh no, we did go straight there. Okay, so an example of of some rules for you to kind of find out about London Borough of Camden. So Camden has had an additional licensing scheme in place since 2015, and this affects the whole borough. So any property in Camden, any house share with 3 or more unrelated sharers, does have to be licensed. So it doesn't matter if the property is purpose-built or not. So when I mentioned about purpose-built flats, that's irrelevant with this additional licensing scheme. Even those purpose-built flats must have a license if there's 3 or more unrelated sharers living there. They publish their HMO list on their website, which is great, because it means that right now, while we're on this webinar, if you live in a flat share in Camden, you could go and have a Google and find whether or not your landlord has a license or not. We've helped quite a lot of students in Camden specifically take action against landlords renting unlicensed properties to students, and that's just because they're quite a proactive borough. So they go out and they check out properties, and many students have found out by accident basically that they're living in an unlicensed HMO. So another example is Tower Hamlet. So they have an identical additional licensing scheme to Camden. So they've got that same 3 or more unrelated sharers that we talked about. But they also, in addition to that, have a selective licensing scheme. So this is, as I talked about, something that applies geographically to a certain area. So as I said, anywhere in Tower Hamlets, 3 or more sharers, they've got to have a license. But in certain areas within Tower Hamlets, so Whitechapel, Spitalfields are some of them, there's quite a few others, I didn't want to list them all here, any property needs a license, so even if there's only 1 or 2 people living there. They also publish a list of licensed HMOs on their website. Brilliant. You can look up your landlord and find out if they've got one. However, one of the kind of less good examples, so London Borough of Southwark, they used to have an additional licensing scheme, which was the same as Camden's, that 3 or more sharers one, and that expired in January 2021. And since then, they haven't renewed it. So now, if you maybe a property that would have needed a license a year ago, no longer does. So if you live in Southwark, then it means that you're on the statutory rules again now. So 5 or more sharers in a non-purpose built accommodation will require a license. So they don't publish a list on their website either, and they didn't even when they had the additional licensing scheme. So that meant that it's a lot harder to find out if your landlord has a license or not. You had to contact them and ask, basically. So the point of this is just to give you a bit of an idea that it is a bit of what we would call a postcode lottery. So where you live makes a big difference about what the rules are, and it can make it difficult for students, especially, to know what the rules are and to, I suppose, take action if they're being broken. Okay, so should your house be licensed? As I've said, small geographical differences make a big difference. One road could require a license, and then the next road in the next borough could not. You can find out what borough you're in by Googling your full postcode and then the word borough, or have a look at your council tax bill if you didn't sort of bin it the second that you found out that you were exempt. You can check your council's website once you know who your council is. Google the borough name and HMO licensing, and that should bring up the page that specifically talks about that. But the guidance can seem quite confusing to the average person. Hopefully with this webinar, it would make a bit more sense to you, but for a lot of people, it is difficult to understand exactly what the rules are. Even I have to read things a couple of times sometimes. You can also use the HMO licensing checker on london.gov.uk. So this is quite useful. It just asks you some questions. So your postcode, your how many people are in the property, some features of the property, and then it will tell you if it thinks that your property needs a license or not. I did try and put the link in there for you, but it's really long. So I suggest you just Google HMO licensing london.gov.uk and it should come up. I can also put it in the chat in a minute, but I'll have to find it myself first, so just bear with me. Okay, so say that you've done all that and you found out actually your property does need a license. So how do you find out if it has one or not? So your council, as I've said before, might have the information on their website. Maybe they'll have published a big list. That's what we hope anyway. You can also call up or email the relevant team who manages that in your council. And I've put a couple of names here because the name is often different depending on what council you're in, what borough you're in. So you can ask for the private rented housing team, the tenancy relations team, or the HMO licensing team. I find that with some councils, when you're trying to get the right person on the phone, you can end up going around in circles, being put on hold, being transferred to a different department, etc. So you might have to be a bit patient there and a bit persistent, but you should get through to the right person in the end who can speak to you about this. It is better to get the answer confirmed in writing, and I'll talk a bit more about why that is later, but it's good evidence if you do decide to take action in future. There is a big waiting list for licenses at the moment. So a lot of boroughs have waiting lists with landlords on there who they need to go out and inspect of sort of in the hundreds. So what this means for you is that because it's the offence basically of not having a license doesn't apply if you've already applied for one and you're just waiting for it to be granted. So you might go to the list on, say, Camden Council's website or Tower Hamlet's website and see that your landlord isn't on there, but that doesn't necessarily mean that they're breaking the law. If they've sent an application, but the council just haven't processed it yet, then they won't be on that online list yet, but they will have kind of done the bare minimum that they legally have to do. So you should also potentially ask the council if your landlord has applied for one, and they should be able to give you an answer on that. The only thing is that they may say that they can't give you that information. I've had this problem before because they say it's a data protection breach. But what I would do is, rather than ask, has my landlord, my landlord John Smith, say, if that's his name, has he applied for a license? If you say, do you have any record of receiving an application for this property? Normally they're a bit more amenable. So that would just be my advice there. So say that you've done all that and you found out that your landlord doesn't have a license. So again, it only matters if the property is licensable. So if you live in Southwark and you only live with 2 other people, then it doesn't matter that your landlord doesn't have a HMO license at the moment, because there's no rules to say that they do need one right now. But if it turns out your property should have been licensable and it isn't, so your landlord can have action taken against them by the council itself. So they can potentially criminally prosecute them. They can also fine them. Also, you have the right to take your landlord to tribunal to get rent money back for up to 12 months. So this is what a rent repayment order is that I mentioned. So that applies basically for the time that the property was unlicensed. So say if like, I don't know, for the first 3 months of the tenancy, there was no license. And then on month 3, the landlord suddenly realized and quickly applied for one. You would only have a case against them for that first 3 months. You wouldn't have a case for the whole tenancy. So it's only for the period where the offence was being committed, i.e. the unlicensed property was being rented out. So what is a rent repayment order? So as I said, so this is tenants being able to apply for rent back when landlords commit certain offences. So it's not always just about licensing, and I'll talk about the other ones in a minute, but licensing is the big one for various reasons. You have to prepare a case and then go to a tribunal hearing normally. So there is an option when you apply saying that you don't want the thing, whether you consent to it going being a paper application, sorry. You can't say that you don't want it to be a hearing, but you can say that you would consent to it just all being done on paper. However, in my experience, this has never happened. It's always gone to tribunal hearing. They're virtual at the moment, so they're usually done over Skype. Quite interesting, I guess. You get to see the judge's fancy study quite often. Yeah, they may go back to being in person at some point. We don't know exactly when that will be. It can be done without a solicitor. So the whole idea of it being at a tribunal rather than a court is it's supposed to be more informal. So the rules aren't as strict. The judge can be a bit more sort of helpful in guiding you through the process when you're in the hearing. And it's just generally just sort of a bit less intimidating for people who aren't used to kind of any kind of court environment. The landlord will often have a solicitor though, so it is quite a good idea to get legal advice, but I wouldn't recommend spending money on it, and we'll talk a bit more about that in a second. You can only apply if the offence was in the last 12 months, so I'm afraid, you know, if it was 3 years ago, it's tough luck there. You can't actually do anything now. But you can apply for up to 12 months rent back if the offence was in the last 12 months. So there used to be some confusion there where we all thought that that meant you could only apply for the rent within the last 12 months of the application date. But what it actually means is if the offence was in the last 12 months at all, you know, say if the last day of the tenancy was 11 months and 29 days ago, you can apply for the whole year of the tenancy, as long as you apply within that 12 months of the last day of the offence. What do you need to consider if you're thinking about taking a rent repayment order out against your landlord? So the first thing is costs. So it costs £100 to apply for the rent repayment order, and then approximately £100 again for the tribunal hearing. So you do need to bear in mind that there is some kind of payment required from you as the applicant. If you're really sort of short of money, you may be able to apply for help with fees. If you're interested in that, you can email us. We've got a little guide about help with fees for students, but it really is if you're sort of not receiving a lot in income at all per month and you've got less than, I think it is £3,000 in savings. So if you know that doesn't apply to you, then it's very likely you'll have to pay that £100. Do you have time to do it, and are you available to attend the tribunal? So as I said, at the moment, they're all being done on Skype, which is brilliant, but we don't know if that's still going to be the case in 6 months. So if you're, for example, leaving the country, you may sort of not do so well at a tribunal because you need to physically turn up for the hearing. Otherwise, they'll just dismiss your case. If you're joint tenants and one of you isn't available, that's normally okay, but at least one of you will need to turn up. Another thing I've actually not written on here is you do need to think about whether or not the other tenants want to do it. If it's just you, it may be more difficult. Does your landlord own the property, and are they a limited company? So if your landlord doesn't own the property, this can make it difficult when it comes to actually enforcing the judgment. If you win rent back at tribunal and then you need to get the landlord to pay it, if they're not actually the owner of the property, then they might not have many assets. And if they just run off and don't pay you, it's a lot harder to kind of track them down to get payment. There's been some recent changes to case law which say that you can actually sort of include the owner of the property if they're not your landlord in the claim, but that's only if they've been receiving part of the rent. So say, for example, if they've instructed an agent who's taking a 20% cut and acting as the landlord, then you should still be able to include the landlord in that. Are they a limited company? So this is important because if a landlord is a limited company, it means that if that company then folds before you get your money, then it's going to be impossible to ever get that money from them. You can't sue the individual behind it. You can only sue the company itself. So it just means that it's quite risky to take a limited company to tribunal for a rent repayment order. There's quite a high chance that even if you win, you might not see the money afterwards. Do you have evidence of the offence? So this is obviously a big one. You need to be able to prove to a criminal standard that the offence took place. So when we say a criminal standard, in a civil trial, so say if you were taking your landlord to court for like a deposit, say for example, if they didn't protect your deposit and you need to take them to court to get it back, the proof that say they didn't have a right to retain your deposit because you didn't damage anything would only need to be sort of more likely than not, right, that you didn't cause that damage, like a civil level of evidence, I suppose. And then with a criminal standard, it needs to be beyond reasonable doubt. So there needs to be very little doubt at all that, or any at all, that the offence didn't take place. So basically what that means is that you need to have proof that they didn't have a license. That's why I said it's good to get it in writing from the council. It's not good enough just to say, well, unless they can produce one, that shows they didn't have one. They need to have proof they didn't have it. And then you also need to prove that there are enough people living there to actually make the offence happen. So this can be difficult in some cases. So if you're on a joint tenancy and there's clearly like 4 of you on the agreement and you're in an additional licensing area that requires 3 or more sharers to have a license, then that's quite easy to prove because you can show you're all on that agreement, you all signed the tenancy, you're all living there. But it's more difficult in cases where, say, for example, you rent an individual room contract and maybe you don't really know the other people who live there. People are moving in and out all the time. You lose touch. It can be harder, and you need to try and get as much evidence as you can, witness statements, screenshots of WhatsApp groups. If you've got someone else's tenancy agreement, that's great. If you don't have cooperation from any of the others, it's not impossible, but it can be hard. So this is just something to bear in mind. Has there been other offences? So did the landlord not protect the deposit, etc.? This can be useful just for building a stronger claim against the landlords, particularly, if you've got tons of evidence. If there was loads of disrepair in the property and maybe the council visited, brilliant. That means that you've got proof that they were not doing so well as a landlord in other respects. Does the landlord have evidence of poor conduct from you? So if you weren't the best tenant, if you caused loads of damage, if there were loads of noise complaints against you, if you put on loads of parties, if things were just not great from your side either, that might impact your case a little bit because they can take into account tenant conduct when they're thinking about how much rent to give you back. So if the landlord's got really good evidence against you that you were not so good, then that could affect your case. You also need to think about enforcement costs. So I touched on this briefly earlier about what happens if you win and then the landlord doesn't pay, or if they're a limited company. So winning the tribunal is only 50% of the job. The other half is actually getting the money. Now, sometimes you might win and then the landlord pays up straight away, but other times they don't. And then there's a whole process that you have to go through to try and get them to pay up. So you need to think about this before you start. This is something that if you come to us for advice, we can help with, but it's considering things like, does the landlord have a property? Do they have assets? Do you know where they live? Are they abroad? Are they a company? If they're abroad, if they're a company, it may not be worth taking the order out just because sometimes it can be so hard to actually get the money off them that you end up just losing the 200 quid to the rent repayment order and then you don't get it back. So this is just something to consider. But again, it's something to get advice on. I don't want to go too much into it here. So what are the steps when you decide to apply? So the first is to fill out the RRO1 form, which is the form on the government website you can find just by Googling. And then you need to prepare and submit an evidence bundle. So this is basically like all your evidence of the tenancy agreement, the fact that the property wasn't licensed, the email print off from the council, proof of you paying rent. You normally need to submit some of that when you fill out the RRO1. And any other kind of relevant stuff. So evidence of the landlord's poor conduct, not doing repairs, any harassment, any kind of lack of deposit protection, all good things to include at this point. At some point, you'll then receive the landlord's evidence. This will all be done through letters from the court, like the tribunal, sorry. You don't just have to kind of know this off by heart, like they will tell you what to do. I'm just giving you an overview here. You'll then receive the landlord's evidence that may or may not have a load of unfounded accusations against you in, so you might need to think about those and then issue a reply. And that's another thing that you would send to the court kind of as part of your evidence. You may have extra evidence to include there if it's kind of countering things the landlord has alleged. You'll then have a hearing. You don't get the result on the day, which is always quite disappointing because, obviously you kind of have all the evidence and all of the kind of emotion and everything, and then you have to wait 30 days to get a result in writing. So that's just something to be aware of. You then hopefully get paid your money back, or you have to start the enforcement process. The whole process, not processing, sorry, excluding enforcement, can take approximately 4 to 6 months. So from the day that you fill out that RO1 form to the day that you get your result, I would say probably about 6 months is accurate. There's been a few delays because of COVID, so it used to be a bit quicker. Why else could someone apply for a rent repayment order other than the licensing? So obviously the first reason is licensing. That's the one we talked about. There's also harassment by the landlord or agent. This has to be to quite a high standard. So bear in mind what I said before about a criminal standard of evidence. You need to have really strong evidence that it is genuine harassment. The same is with violent entry to the property. So this is normally when it's talking about illegal eviction, if the landlord chucks you out. Unless this was the landlord himself doing this can be really difficult to prove. And again, you'd quite often need something as ridiculous as like a video of them doing it. It's like the standard of evidence for illegal eviction is that strong. So that's why we don't tend to really go down this road for illegal eviction, just because in my experience I've not taken one myself, but just from reading about this, it's really quite hard to prove it to the criminal standard. If the landlord broke a banning order, prohibition notice, or improvement notice, so if they were issued a prohibition order saying they couldn't rent that property out anymore, and then they rent it to you anyway, that would be a breach of that, and you would potentially be able to get a rent repayment order for that. So just to give you an example case of one that I had, so 4 UCL students sharing a property in Camden. The local authority turned up because there was a flood in the property and noise complaints from other neighbours regarding the students, and then they discovered that the property was unlicensed. The landlord didn't do anything about that. The council wrote to them and he did nothing. But the local authority decided not to prosecute the landlord after he finally did apply for a license after 6 months. But the students applied for the tribunal for the 7 months rent back, which was £21,000 for when the property was unlicensed, and they were successful. They got all that money. So it just goes to show that, students can get quite good results out of this. When the tribunal looked at that case, they looked at quite a few factors. So one was the tenant behaviour. So because there'd been these noise complaints, we thought that might be something that would mean they would potentially lose out, but they actually didn't. It was pretty good. They kind of weren't too worried about that. I think the tenants had good evidence that they hadn't really done anything wrong, and it was partly to do with the fact that the landlord hadn't put a carpet down, so that was why it was so noisy when they were walking around in their flat. The landlord didn't protect the deposit and didn't really do repairs, so this really didn't reflect very well on him, and that's why the judge was a lot more willing to give them all the money back. But they did also look at the landlord's income and circumstances. So in previous older hearings, this was more of a thing, because the landlord used to be able to claim back a lot of their costs of things like repairs and stuff like that off the rent repayment order, so it'd be reduced. Say if the landlord had bought a new boiler for £5,000, potentially that would mean £5,000 less would go to your rent repayment order. But they've changed that now, so it's a lot harder for landlords to do that, so we don't focus so much on it anymore. So if you think you want to potentially pursue this and you think you might have a case either now or in the future, then places you can get help from to actually do it. So as I said, it is designed really to be done by tenants, but it can be a bit difficult for the average person to do on their own. So it is good to try and get a bit of advice while you're going through it. So obviously we can help you, so we can give advice, we can sort of try and help out, and we can try and support you at the tribunal itself if we're available, but we can't represent you. So the difference there is that basically when we go along, we go as something called a Mackenzie friend, which is someone who is with you in court, can offer you some advice to you personally, but they can't speak to the judge or speak on your behalf. So that's what we would do. If you want representation, then you could consider getting a solicitor, but as I've put there, it costs a lot of money, and I wouldn't necessarily recommend it, because you can do it without one, and then you don't lose out on legal costs because you won't be able to claim those back from the landlord. There's also no win, no fee type organisations. So I would recommend getting in touch with Justice for Tenants or Flat Justice. Both of them are great organisations that give a lot of free advice to tenants about rent repayment orders, but they can also take on cases and represent you, and they won't charge you anything unless you actually win the case and get some money back. The fees for them vary. I'm not entirely sure on what they are at the moment. They seem to reduce quite a lot recently from what I understand. So the best thing to do would be to contact them, and then you can find out basically how much they would charge you for your case. They may not be able to give you an exact estimate, but you'd get a rough idea. The good thing about using them is basically that they'll do most of the work for you. You still need to be around to actually help them compile evidence, but in terms of the legal stuff and the enforcement, I think they do a lot of that for you. So that's just something to bear in mind because if you come to us, we will try and help you, but you'll have to be quite independent with it. There's also a self-help guide produced by Flat Justice, which is very useful. I quite often use that to refer to if I just need to quickly check something that I'm not 100% sure on. All you need to do to get that is to go on their website and enter your email address, and they'll send you the link. You can also go to renters unions, so places like London Renters Union or Acorn. So they offer advice to tenants. You usually have to pay to be a member of the union, but it can be good from a general kind of tenant's perspective because it's kind of organizing in a way where you can get advice from kind of peers who are also tenants and more experienced, and get a bit of support if you have further issues on an ongoing basis. There's also other legal advice centres, so you can look at your local area, see if there's a free legal advice centre. We do have a list actually that you can contact our office for if you want to look at our alternative advice guide, but it may not include all of them. But some of them will take on rent repayment orders, but it depends on your circumstances. Sometimes they'll limit who can use those centres based on maybe where you live or what your circumstances are. So these are our contact details for you to get in touch with us if you've got any more questions about rent repayment orders, HMOs, or just generally if you've got an issue with housing and you want to get in touch with us for some help, want to get your contract checked, that's how you get hold of us. If anyone's got any questions they want to ask about this presentation, I'm very happy to take some now. If you just submit them via the Q&A, that'd be great.